Hello friends, in the series on the income tax cases, today we will discuss two very important issues which has been decided by Kolkata ITAT B bench in the case of Onkar Society for Engineering and Technological Research versus Income Tax Officer. This case has been reported in 110 ITR Tribunal, page number 393, and the case has been decided on 2nd February 2024. In the present case, the assessment year was 2021. The assessee was registered under section 12A and the assessee was claiming the exemption under section 11. For the assessment year 2021, the extended due date for filing the return was 15th February 2021. But the assessee filed its income tax return in the form ITR 7 and the audit report in form 10B at the fag end of March 21. CPC disallowed the exemption under section 11 on the reason that since the assessee has not filed the return and the audit report up to 15th Feb 2021, section 11 exemption was denied. The assessee filed the appeal before the CIT appeal. The CIT appeal also upheld the order of the Central Processing Center CPC. When the matter was before the tribunal, the assessee came with an additional ground that in the case of the assessee was not given any opportunity to prove his case, or the assessee was not issued any notice for the disallowance under section 143 subsection 1 for denying the exemption under section 11. There was no communication either in writing or in the electronic mode before disallowing the exemption under section 11 by the CPC. It was the viewpoint of the assessee that the technical ground or the legal ground can be raised by the assessee at any level of proceedings, because there is a Supreme Court judgment in the case of National Thermal Power Company Limited versus Commissioner of Income Tax, which was decided in 1998 and which is reported in 229 ITR at page number 383, in which the Supreme Court held that any legal ground which does not require any new facts to be brought onto the file can be admitted at any stage, either by the CIT appeal or by the tribunal or by the High Court or the Supreme Court. So, first of all, the question was that whether this additional ground can be taken by the tribunal at this stage. The tribunal said that it can be taken, and the tribunal deleted the disallowance only on this ground also, that in the present case the CPC has not followed the mandate of section 143 subsection 1 in giving the opportunity to the assessee before making any disallowance under section 143 subsection 1 by denying the exemption under section 11 only on the ground that the return and the form has been filed late, or in other words it is not filed in due time. Secondly, the tribunal said that the Supreme Court by its order extended all the timeliness for the judicial and quasi-judicial proceedings during the COVID period. So the question before the tribunal was that whether that extension by the Supreme Court will apply for filing the income tax returns and for filing the various income tax forms. So the tribunal said that because that timeliness has been extended by the Supreme Court for the judicial and quasi-judicial proceedings, so that timeliness will also apply for the income tax returns and for the income tax forms in the present case. Friends, on both the grounds, the tribunal gave relief to the assessee. Sometimes it may happen that we are fighting our case on the merits, but we have very strong case on the legal grounds. So in the present case, it is very clear by following the judgment of the Supreme Court in the case of National Thermal Power Company Limited versus CIT 1998 that the legal ground can be raised at any stage. So we should search our files, we should examine our files with the lens that if there is any technical ground which we can take at any stage. At the end of this video, Once again, I am repeating the name of the case. The name of the case is Onkar Society for Engineering and Technological Research versus Income Tax Officer, and this case has been reported in 110 ITR Tribunal at page number 393, and the matter has been decided by Kolkata ITAT B bench, and the date of the judgment is 2nd February 2024. Thank you, friends.